Welcome, everyone. My name is Matt Nelson, and I'm based in the National Center for Contemporary Islamic Studies at the University of Melbourne. I'm delighted that you're with us. Today, we'll be talking about a crucially important topic, namely Understanding Sharia, Islamic Law in a Globalized World. This is, of course, the title of an exceptional new book by Rafiq Abdullah and Mohammed Keshavjee. Now, Dr. Keshavjee will be joining us in just a moment to discuss his work. When someone says Sharia, connotations rush in: rigid, patriarchal, divine, complex, and so on. But of course, Muslims around the world refer to the norms associated with Sharia every day. And they do so in many different ways. Today, we'll be talking about Sharia and trying to make it a bit more understandable. To host this event, we're honored to have two institutions with a very strong interest in understanding Sharia: the Institute for Ismaili Studies in London, and in Australia, the National Center for Contemporary Islamic Studies at the University of Melbourne. We also have a very highly regarded panel of experts to help us do this. And to start, Professor Abdullah Saeed from Melbourne is with us just to say a brief word of welcome and to introduce our speakers. Already known to many of us, Professor Saeed is the Sultan of Oman Professor of Arab and Islamic Studies, and now a Redmond Berry Distinguished Professor at the University of Melbourne. He's also a Fellow of the Australian Academy of Humanities and a member of the Order of Australia. Among his recent books are Contemporary Approaches to the Quran and Its Interpretation in Iran from 2019, as well as Islam and Human Rights from 2018. So, Professor Saeed, thank you very much for joining us.
Thank you, Matt, and welcome everyone. This webinar is a collaborative project between the Institute of Ismaili Studies in London and the Asia Institute and the National Center for Contemporary Islamic Studies at the University of Melbourne. Let me say a few words about our partners. The Asia Institute focuses on teaching and research in Arabic, Japanese, Chinese, Indonesian, Islamic, and Asian studies. The National Center for Contemporary Islamic Studies at the University of Melbourne was established in 2006 with a focus on teaching and research in contemporary Islamic studies in Australia. The Institute of Ismaili Studies is based in London. The Institute's research, publications, and educational programs seek to promote scholarship in the fields of historical and contemporary Muslim cultures and societies. A core part of the Institute's mission has been to preserve and study the intellectual and literary heritage of Shi'i Islam and its Ismaili traditions in particular. The Institute adopts a civilizational approach to the study of Islam. It explores the plurality of our contemporary world and its complex relationships with the intellectual and cultural traditions related to Muslim societies. In all of its programs, the Institute strives for an atmosphere of openness, tolerance, and diversity. A question for us is, why is this topic of Sharia so much on our minds these days? I mean, those of us who are based in Western countries in particular, like Australia and the UK. For many in the West, the term Sharia can evoke extreme fear. It reminds them of barbaric practices and severe punishments. It represents a foreign and strange system of law that attempts to curtail the freedoms and rights we have in the West. But for many Muslims, Sharia may simply mean just a set of norms, guidelines, and rules for Muslims to function in their day-to-day life, perfectly compatible with the modern context. Between these two views, there are, of course, many other views of Sharia. But rightly or wrongly, in the West, debates about Sharia are very much associated with a whole lot of problems that are real or imagined. It is about the place of Muslims as participant citizens in Western countries. It is also connected with the debates on integration, community relations, Muslim identity, and Muslims' ability to adapt to modern norms about governance, human rights, interreligious relations, and the like. So it is so important for us, based in London and Melbourne, and of course elsewhere, to get a handle on what this concept of Sharia is and what it is not. There is an urgent need to demystify it. This is where our webinar today is so timely. We are fortunate to have the author of an extremely important book on demystifying Sharia in an easily accessible text. We also have other scholars who have been engaged in this debate on Sharia with us tonight to really explore some of the key issues the book focuses on. Let me now introduce our panelists very briefly. To guide us, we have Matthew Nelson in conversation with the author of this helpful new book, Mohammed Keshavjee. And then to discuss this work, we also have two extremely distinguished colleagues, Layla Arstal and Ziba Mir Hosseini. Matthew Nelson is an associate professor in the Asia Institute at the University of Melbourne, focusing on politics, law, and Islam in South Asia. Before arriving in Melbourne, he was a professor of politics at SOAS London. He has also held visiting appointments at Yale and Princeton and so on. Mohammed Keshavjee, the author of today's featured book, is a South African-born lawyer called to the bar at Gray's Inn in London before practicing law in Kenya, Canada, and the UK. He also completed his PhD at SOAS with a focus on Islamic law. Also focusing on law in multiple contexts, Layla Arstal is a solicitor who practiced for many years with an international law firm in London. She spent the 1990s in Singapore, then returned to the Channel Islands, where she now works with a law firm on tax, trusts, and private wealth structures. Ziba Mir Hosseini is, of course, a well-known legal anthropologist specializing in Islamic law, gender, and Islamic feminism. She's a professorial research associate at SOAS, focusing on Islamic family law in Iran and Morocco. She's also a founding member of the Musawa Global Movement for Equality and Justice in the Muslim family. Thank you all very much for joining us.
Thank you, Abdullah, for welcoming us. I think to start, what we should do is just take a few moments to hear from Dr. Mohammed Keshavjee. Mohammed, if I may. Perhaps you could just take 15 or 20 minutes, perhaps, and outline the key features of your book and introduce some of its main themes. And from there, we'll jump in with a few questions. I know I have a few questions myself, and I'm sure Dr. Ziba Mir Hosseini and Layla Arstal, again, Ziba and Layla, if I may, we'll dig a bit deeper. It's such an important and engaging topic, but it's also unfamiliar to many people. So maybe you can just help us get started in ways that will help us understand Sharia. Mohammed.
Good day, friends, wherever in the world you are. Thank you, Professor Nelson, for your very kind words. My warm thanks to Professor Abdullah Saeed for inviting me to this event at the University of Melbourne to discuss my co-authored book, Understanding Sharia, Islamic Law in a Globalized World. I'm also grateful to Dr. Salim Lakha for all his help in making this event possible. My thanks also go to the Institute of Ismaili Studies here in London, from where this program is being aired. Perhaps it's a good starting point for me to explain very briefly what motivated me and my co-author, the late Rafiq Abdullah, a fellow British-trained barrister and a diasporic Muslim like myself, to write a book on Sharia. Both of us spent many years of our lives working with Muslim communities and institutions in different parts of the world. In my case, in an international capacity in France, in the case of my co-author, with a Sharia council in the United Kingdom, primarily as an advisor to the council to ensure that its deliberations accorded with the public laws of the United Kingdom. In our respective work, we came to realize that basic knowledge of Sharia was sorely lacking in the United Kingdom, a country that has some 3.6 million Muslim citizens today. Primarily from the point of view of private international law, there have been cases each day in the courts of the United Kingdom affecting countless Muslims who come from some 58 different Muslim countries with different legal systems where Sharia features in one way or another. This, as you can imagine, is not an easy task, considering that there are 8 different schools of law in Islam, 4 schools for the Sunnis, 3 for the Shia, and the Ibadi school, followed by the Kharijites, who are neither Sunni nor Shia. Secondly, we noticed that in the public perception, there was no clear idea of what Sharia was or was not. Many practices followed by Muslims, including in the UK, were viewed in the public perception as, quote, Sharia, unquote, practices, e.g. forced marriages, crimes of honor, and female genital mutilation. Whereas in reality, Sharia does not countenance such practices which are cultural and not mandated by the faith. Sadly, Sharia has become a metaphor today for the erroneous perception that Muslims are unable to live their faith in harmony with the exigencies of the modern world. Sharia thus is thought to lie at the fault line between tradition and modernity, and between the so-called liberal, enlightened West and the so-called pre-modern East. Muslims are seen to be tenaciously holding on to a legal system that appears draconian and has little or no compatibility with legal systems in the Western world. A perception both caused and sustained by Samuel Huntington's thesis of the clash of civilization, which is buttressed by rampant Islamophobia that today has acquired a normative status in the media channels globally. Thirdly, among Muslims themselves, there often is no clear understanding today between what Sharia is, a divine pathway, and what fiqh is, its real-world jurisprudential understanding. While Sharia is considered to be a divine and unchangeable ideal, its fiqh, or time-marked jurisprudential understanding, is human and therefore subject to change according to the vagaries of time. This understanding, we felt, was an important factor for us to explain, as many Muslims today call for a return of Sharia, often not understanding what this rallying call actually means. In diasporic settings, the call for Sharia often has a different motivation. It is a desperate call for the buttressing of identity in a world facing massive globalization. Here, identity becomes an important factor, and Sharia becomes the term around which identity politics are played out. We saw this in the Sharia debate in Ontario in 2004, and in the United Kingdom in 2008, when the then Archbishop of Canterbury, Dr. Rowan Williams, gave his famous speech at the Middle Temple Inn in London, suggesting that in some matters of family dispute resolution in the United Kingdom, some aspects of the Sharia could be applicable. Reactions to the Archbishop's speech focused more on identity politics rather than on legal practice, and consequently, this speech became the subject of a major controversy. Lastly, in the case of my co-author, the late Rafiq Abdullah, working on this book was a case of intellectual and personal curiosity. Rafiq grew up in a Sunni Muslim home in South Africa, and his mother was the granddaughter of two imams, one of whom was sent by the Ottoman Sultan Abdul Hamid II as Sheikh al-Islam to South Africa. While Rafiq's family lived as Muslims, Sharia as such was not a conscious daily obsession in their home. And he was intrigued to know why Sharia had become such a prominent factor in Muslim identity in recent times. We therefore felt that there was a need for a book on this subject for the educated lay person that would be accessible and not too academic. Hence this book, Understanding Sharia, Islamic Law in a Globalized World. This book, Understanding Sharia, Islamic Law in a Globalized World, is not a book on fiqh. It is not meant to be. It is instead a book that provides perspectives on the term Sharia, showing inter alia how ideas about Sharia developed into positive law in the context of the history of the various Muslim peoples and how, at different times, Sharia interfaced in a creative manner with different legal systems in different historical circumstances. Sharia also interfaced creatively with urf, customary law, in various parts of the world to which Islam expanded. For example, Yemen, Indonesia, Morocco, India, and Zanzibar. In this regard, the book provides a historical background showing how Sharia evolved in each epoch. In the formative period, 622 to 632, Sharia evolved as a bare legal ethic where the conflict was between tribal and customary norms on the one hand and the new Quranic norms and rules on the other, which, for the first time, gave property rights to women as witnessed in early inheritance cases. As Islam expanded geographically, we see further development in the time of the first four caliphs, when Sharia takes the form of capacious moral guidance for governors, primarily for the sake of good governance. Following the era of the four rightly guided caliphs of Islam, at the outset of Islam, we see the rise of the Umayyads with the establishment of the Qadi court system and the formation of secular courts, which were not Sharia courts, but courts which coexisted with Sharia courts, with both dispensing justice in the name of the faith in a seamless manner. Our book, Understanding Sharia in a Globalized World, then describes legal developments in the next phase, when the Abbasids take power, 750 to 1258 CE. And here we see the formation of the four Sunni schools of law and the contested notion of the closure of the gates of independent reasoning, known in Arabic as ijtihad. Quite exceptionally for the Western Hemisphere, this work for the first time also provides a background on the sheer understanding of Sharia and the evolution under the guidance of the hereditary spiritual authorities or imams from the progeny of the house of the Prophet, who are known in Arabic as the Ahl al-Bayt. Other chapters in the book deal with specific topics, such as the multiple manifestations of Sharia and its controversial expressions in much publicized media cases, such as the Amina Lawal case on adultery in Nigeria, the Abdul Rahman case in Afghanistan on apostasy, and the Mukhtaran May case in Pakistan based on informal justice. These cases are analyzed to show the tension that exists in a modern Muslim nation state and states with large Muslim populations between what is stated in the constitution, what is practiced in the field, and how matters eventually become resolved. This often happens with the country being called to account on the basis of its commitment to human rights treaties. What at times is not known is that in the case of Amina Lawal in Nigeria, for example, it was a Sharia court that convicted her, but it was also a Sharia appellate court that acquitted her on the basis that Sharia evidentiary rules had not been satisfied. In the case of Mukhtaran May in Pakistan, it was an imam of the mosque who, sensing injustice in the tribal council or Jirga, alerted the BBC to the case. These cases are also discussed in the context of the political circumstances in which they took place. This book, Understanding Sharia in a Globalized World, then discusses new developments that reference Sharia. These are Islamic finance and alternative dispute resolution. While Islamic finance attracts favorable attention, alternative dispute resolution invites concern and fear and becomes embroiled in the politics of informal justice. In the field of private international law, the book highlights the successful collaboration with regard to the 1980 Hague Convention on International Interspousal Child Abduction. It was as a result of mutual respect and dialogue that some 500 million Muslims who formally shunned the convention came within its ambit in a little over a decade. The chapter on human rights in the book focuses on the different philosophical approaches to the subject and concludes with Elizabeth Meyer's point that neither Islam nor human rights are static entities and that their relationship is not essentially conflictual. Rather, they are the products of politics, which creates a changing and malleable relationship which is both hostile and promising. The book ends with a critique in which the authors describe both the need for ongoing interpretation of Sharia and the complexity involved in the process. This critique focuses on the work of Muslim female scholars, such as Aziza Al-Hibri, the American academic, Amina Wadud Musin, a modern-day interpreter of the Quran, and Ziba Mir Hosseini, an anthropologist of Iranian origin. The critique further covers the social activism of the Sisters in Islam in Malaysia and of the late Asma Jahangir, the human rights lawyer in Pakistan. There is also a reference to more grassroots activists such as Tawakkul Karman of Yemen and Malala Yousafzai of Pakistan, both Nobel laureates, highlighting that Sharia was never the dominant factor in Muslim identity, but one of many factors. Our critique ends with the sentiment with which the book begins, in the words of Jacques Jomier, and I quote, "Islam is a clear stream with well-defined characteristics which are the same everywhere. But the ground over which the stream flows can be varied. Moreover, in each case, the water will take on the color of the shores, the sand, or the earth which forms its bed." Thank you very much.
Thank you so much, Mohammed. That overview of the book, that sort of introduction to the key themes, the sort of basic outline of your ideas and what you intended to do with the book was extremely helpful. And we can now appreciate why this is such an important book. What I want to do now, I think, is just start a conversation. Building on what you've said, and sort of asking about some of the key terms that you introduced and going into a little bit more detail, I think. I know I have a few questions, and I'm sure that Layla and Ziba will as well. So I think I'll just go ahead and get started with a question of my own, if you don't mind. Of course, we're familiar with the term Sharia, but you also reference another important term, which is the term fiqh, or F-I-Q-H, fiqh. And in the book, this is an important distinction. And I'm wondering if you can just tell us a little bit about this distinction. When we say Islamic law, why do these terms come up and how can we distinguish them? Maybe just walk us through some of those terms.
Thank you, Matt. Very interesting question. If I may, I'll just refer to a particular slide that appears in the book. If you look at this slide, a Muslim, the red dot on this particular slide, has various relationships. One relationship is between a Muslim and his or her creator, which is what I would call the vertical axis or the vertical coordinate. And that is called ibadat. That connection is exemplified by the 5 pillars of Islam: the Shahada, the pilgrimage to Mecca, the giving of zakat or alms, the daily prayer, and the fasting during Ramadan. But a Muslim also has a lateral relationship with his or her fellow human beings. And that lateral relationship is known as mu'amalat. It's a transactional relationship. And on that particular axis, you have things like contracts, torts, marital relationships, marriage contracts, divorce, custody cases, criminal justice would all come on the muamalati transactions. But we also say there's a third connection, and that's the connection with the environment. And that is exemplified by the notion of amanat or custodianship, a trustee position that you cannot deplete the patrimony of the earth in a lustful and greedy way, but you have to look after it for future generations. And we make the point in the book that there is a linkage from God to the environment, which is the ideal called Sharia. It is an ideal. It is a moral vision that is God's vision for Muslims on how they should continue their life. But that is a straight line, but it's not a rigid line, because successive Muslim generations had to interpret what that meant according to the context of the times in which they lived. And that jurisprudential understanding is known as fiqh. And that is mediated through a human agency. While Sharia as an ideal is considered to be a divine construct, its jurisprudential understanding is a human construct. And this would be important for people to know, particularly for those who take an egregiously literalistic approach to this whole concept and say that everything is immutable, that you cannot even use human agency to try and understand it. Now, I think that is very important distinction for those who call back for return to Sharia. Now, as far as, and I think this particular distinction is very well covered in the Ziba's work, among others. I think your question about Islamic law, how we visualize it in the book as 2 British-trained barristers, is Islamic law is the dispositive law that a Muslim country would utilize in terms of dealing with an issue that has a Sharia dimension. And Islamic law would be laws that that country follows, which could be statutory laws. It could be also laws that they acquired from the colonial overlay. It would be laws based in Sharia. It would be laws following the fiqh. And it would also include Sharia customary laws. So Islamic law is what lawyers would normally refer to in the way a particular matter would be disposed of in the courts of countries in the Muslim world. Now, these are our approaches to categorization, and there could be a number of categorizations in the number of books that have been written on Sharia.
Fantastic. That is very helpful, that description of these two key terms. On the one hand, your reference to the notion of Sharia as this sort of ideal moral vision. And at the same time, on turning to fiqh, this notion that humans will constantly exert themselves to understand that ideal moral vision and then apply that interpretation through their activities in all the different domains that you just mentioned, whether it's statutory law, whether it's other examinations of customary law, and so on. When people mention the word Sharia, however, this particular word, Sharia, as I mentioned at the outset, it comes with all of these connotations. Some connotations are very positive, as you indicated as well, references to Sharia finance and so on. But we find that many people think that the connotation of this term has a negative flavor, sort of a flavor that leads them to feel anxious and apprehensive about this term. Why is it, in your opinion, that this sense of apprehension about that term has come about?
You know, Matt, that's a very interesting question. I've often pondered it. And one thing from my own experience, and both Rafiq Abdullah, with whom I worked on this book, you know, as far as Sharia finance is concerned, where do the discourses really take place? They take place in conference halls of five-star hotels. Where do you find a lot of imams coming along in pinstripe suits, investment bankers, financial analysts, financial journalists, and they have a discourse in beautiful five-star context in Kuala Lumpur or Bahrain or Dubai or New York or Hong Kong or Paris. Where do the discourses about the other aspects of Sharia take place? And the discourses on the other aspects take place in contexts where they're discussing women's rights, minority rights, custody matters, interest of the child. And so the discourses are in a different context to start off with. There's no level playing field to start off with. Secondly, you see some controversial expressions of Sharia justice coming out from certain quarters of the Muslim world. And when this happens, unfortunately, those very few examples, and they are really very few. I mean, in writing this book, I came just across 4 or 5 maximum. But the interesting thing is they are so dramatic that they tend to dominate the whole discourse in the media, particularly. And then the Islamophobic tropes that have become part of mainstream culture today play in. And therefore, you begin to see that it takes a binary shape of discourse, where it is demonization. But what is not known, and hopefully this book does it to a certain extent, that the Amina Laval case, for example, it was a Muslim lawyer, Nigerian woman lawyer, Huhaba Ibrahim, who fought this case and proved that the Sharia principles of justice were not met. And on the Sharia principle of justice, the woman was acquitted. So these type of analysis are not known. The media is not interested in how Huhaba Ibrahim fought the case. They're interested to know that is Amin al-Laval going to be executed, and is Nigeria going to be in a problem? And does this become a global media discourse? Now, while one can understand the concerns, and this book is not written in an apologetic manner. We've dealt with issues of female genital mutilation. We've dealt with these issues of forced marriages. But the important thing is that we need to understand the issues before we are in a situation to start passing judgment, to say barbarianism, bad behavior. But what happens is the book tries to situate this in the context of the political circumstances in which these cases have taken place. And I think that in any discourse, one has to look at the facts, and wherever things are wrong, to say they are wrong. hopefully we have tried to do this in the book without being judgmental.
Okay, I have to bring in Dr. Zibamir Husseini at this point. As you've said, the media might have its own framing of these issues, but the rest of us who, as you say, want to understand Sharia, obviously want to look a little bit deeper from some of those frames that we're presented with. And you've specifically referenced many cases that have to do with women Sharia and some of the stories that we hear about that. And so I just have to call on Dr. Zibamir Husseini. Perhaps you have some thoughts that you just want to bring in on these issues. Obviously, your work is very influential in this area.
Thank you. Thank you for inviting me to join this conversation. I very much enjoyed the book. Yes, I think one point that Mohammed made, which is a very important, the distinction between Sharia and fiqh, that fiqh is basically a human understanding of Sharia. But I would say it's not the human, because it is a man's understanding until now. Because in pre-modern times, this is not the case at the time of the Prophet Muhammad. But after the Prophet Muhammad, women were gradually marginalized, and their voices were silenced. And by the time that fiqh schools emerged, 150 years after the death of the Prophet, women's voices were not there. And so as a result, what we see as an interpretation of Sharia, a juristic interpretation, is a man-made interpretation. And also that belongs to a different time and different age, that the idea of gender equality, the way that we think about it, was not a component of justice, but things have changed. So now I would say since the early 20th century, we have this debate that Muslim thinkers, and Abdullah Saeed is one of them, thinking about the new interpretation of the Sharia, the new ways of understanding of Sharia. But I want to say that it was not until the end of 20th century that, after seeing the rise of feminist voices and scholarship, that we actually entered this debate in a very serious way. And Dr. Keshavjee really touches on this point in his book, but I would really like you to reflect on it, and to reflect on the idea of the role that women, Muslim women, are now playing through their demands, through their activism and scholarship, in making it possible to have women's voices included in understanding of the Sharia, in jurisprudence, and also the idea of gender equality. How do you see it?
Ziba, thank you so much. And coming from you, I love that question. Ziba, our book references the work of people like Siti Mustamulya in Indonesia. She's doing some very interesting work. Isatu Ture in Gambia. It talks about social activists like Asma Jahangir, the late Asma Jahangir of Pakistan, who you may have met. I've never met her. And also people like Tawakkul Karmani in Yemen, Malala Yousafzai. But let's come to the point you've made, and I'm very happy you've made it, that today, if any serious work had to be done on the Sharia, I do not think anybody can ignore the type of fascinating work that you've done among other Muslim women. And any discourse of the Sharia in the 21st century would ignore that voice at the peril of sound scholarship. Now, your work in this field has been very influential. I think in the case of alternative dispute resolution, my mind goes to the work of a woman called Sonia Shah Kazmi, who died literally 6 weeks ago. And I'm amazed at the type of work Sharia or work she did on alternative Muslim justice, which is very understated, under-recognized even by Muslim scholarship in Britain today. Not only did Sonia do work on a Sharia council in Britain, but she also challenged the conceptual processual framework of a very leading anthropologist called P.H. Gulliver. See, in cross-cultural work, Sonia's work is not only interest to Muslims, it's an interest to the whole field. Then I think of constitutional work, work like Ashifa Qureshi in the United States, who's doing serious theoretical work on constitutions. Now, given the context of the time today, where we are not dealing on this from purely a Muslim point of view, if we had to now talk about alternative justice, we can't talk as Muslims as footnotes. We have to participate in the whole discourse of alternative justice and looking at it from the vantage point of how we as Muslims will look at it, rather than saying, yes, that's all very good. We also are good. We do good things. I think we got to be right in the trenches and start discussing these issues, not only for ourselves, but for the understanding of this discipline itself. And given the present century, I cannot see the Muslim female voice being ignored. I think not only is it necessary, it is inevitable and it is welcome. And I would like to cheer you up to say that in the next book that myself and Hadi Inayat are writing together, exactly the type of work you've done is the subject of the discourse that we need today. We cannot go back to the point by saying, oh no, women are okay, we respect women. That's an apologetic discourse. I think the discourse now has to take on that voice for what it has to say, not only in terms of what the past was, but what the present has to be. And I would welcome very much that voice. I'm sure you're aware of the fact that both Rafiq Abdullah, before he died, when the book was launched, Rafiq's first question to people, when that question came up, he said, what would my mother say? He said, my mother was a doctor who established my life. She taught me to read. She took me to the theater. She taught me how to enjoy music. Her two grandparents were imams. And if I told my mother that women have no voice, he said, where would I be? So thank you, Ziba. It's a voice we need to now embrace.
This conversation that we've just witnessed before us is a dynamic, multidimensional conversation with many different voices, and yet still there are some people who tend to see the space of Islamic law as a space that is frozen, that is inert. But coming back to the specific parameters of Sharia, we also know that within those parameters, there are inbuilt mechanisms, specific mechanisms, whereby the terms of Sharia constantly respond to changing circumstances. And what I'm getting at is specifically the notion of the fatwa, right? A practice that is embedded within the tradition of Sharia that allows for a relationship between those terms and specific circumstances, the specific circumstances of an individual with a question, the specific circumstances of people who want to integrate their circumstances with this broader tradition. Can you tell us just a little bit about, again, this very important term, fatwa, and how it works? And then I'm gonna bring in Layla, I think, who will have something to tell us a little bit about how the action of Sharia works in the world today. But first, a little bit about the fatwa.
Yeah, thanks, Matt. The fatwa is an interesting concept. Basically, the fatwa is a legal opinion. It's a legal opinion given by a person who's qualified to give that legal opinion, which is a mufti, a jurisconsult. And it's a legal opinion, that's all. It is not binding. A Muslim will be no less a Muslim if he or she didn't follow a particular fatwa. But a fatwa would have certain credibility by virtue of the scholarship of that particular mufti. Certain Muslim countries have official muftis, and certain Muslim contexts have muftis that are not working for the government, but that acquire a certain credibility. Now, the jurisconsult gives that opinion. And for us as two British trained barristers, the first thing Rafiq and I said, but really a fatwa is what they do in British common law. The whole notion of ratio decidendi. A judge looks at a particular issue, looks at earlier rulings, tries and distinguish the earlier rulings according to the facts of the case in the later ruling, and says to that extent the earlier ruling has been overruled, and because of these distinguishing factors, this is how we would dispose of the case. So it is very much like British common law and the notion of ratio decidendi. And the fatwa is a process by which Islamic law gains currency in terms of the exigencies in which Muslims have to deal with matters. There are fatwas passed in Indonesia about how the rainforest has to be cared for. There is a fatwa being passed or was passed recently in Britain on whether Muslims could donate their organs. And a program I'm teaching here at the Institute has an imam who's going to come and say how they developed this fatwa with Muslim doctors, with scholars, with experts. So a fatwa doesn't just emanate in thin air. It is a thought out process where you bring in experts in the field. In the case of Islamic banking, the Egyptian mufti said, look, we can't go back to the 10th century jurisprudence and look for something for the 21st century if it didn't exist at that time. But we can take the principles of the past in terms of its essential values and try and extract a voice from the past that can speak to the present. Unfortunately, the word fatwa acquired a negative connotation after the fatwa that was passed by the Ayatollah Khomeini against Salman Rushdie many years ago. But that was precisely a legal opinion given at that time. And also remember, the Mufti has to look at three internal principles of the dynamic of Sharia. One is necessity, which is known as darura. The second is public interest, which is known as maslaha. And the third is the process of ijtihad, the exertion of the human mind for the understanding of a problem. So I think the fatwa is in that particular dynamic.
When we're talking about the fatwa, we're talking about the work of legal experts. And so again, I want to bring in a legal expert, in this case, Leila Arstal, to tell us a little bit about her views on some of the issues we've been discussing. When we've been discussing the fatwa in particular, again, it's about how to connect the terms of Sharia to some of the demands and changing circumstances that unfold in the world. And the world is constantly changing. And so it's important to think about how Muslims engage a changing world. And I know that Leila is involved with Muslims involved in a changing world every day. And so as an expert opinion and a solicitor herself, can you jump in, Leila, and help us think about some of these issues from your perspective?
Well, yes, thank you very much for posing that very interesting question, but it's also multi-layered. And as Abdullah, Ziba, and Mohammed has explained, that there are so many different ways, perspectives that we need to consider each problem. As far as understanding Sharia is concerned, and Mohammed's book is very helpful in addressing the challenge that Abdullah mentioned right at the beginning, which is demystifying Sharia law in terms that can be understood by the educated layman. And I think if we keep on going back to that and then referencing authors like Mohammed and like Ziba, who have written in spaces to explain these technical terms that non-Muslims would find useful as tools to then understand what Sharia law is, how to place a fatwa, how to understand fiqh. And then going back again to Abdullah's point of making this available to the educated layman, and drawing in the point that was made earlier about the media, I'm wondering whether actually the priority group is to educate the media in how to use these terms sensibly without jumping onto perhaps the bandwagon of a sensationalized story that will sell newspapers. Now, that's an aspiration, but I'm not sure whether it's one that can be addressed in the immediate future, but certainly conversations like this, books like Muhammad's, bringing in multiplicity of voices and disciplines, not just from the jurisprudence side of things, but people who are practicing in normal transactional worlds can bring to bear. So I think going back to your question, Matthew, the Sharia principles are there. and it's the bedrock from which we can draw essentials, and then using the tools of fiqh and fatwa, be able to apply them, but recognizing, as Ziba said, that these are interpretations that up until now have been mostly dominated by the male voice. Going forward, let's hope that there will be a pluralistic approach to these man-made tools. I hope that addresses some of the question that you asked.
Absolutely. I mean, of course, the media and those working in media often view us as their audience. But what you're suggesting, in a sense, is that some of this task of understanding Sharia needs to treat the media as an audience and hope that they will start listening to some of the things that we're articulating here, and to make it, in a sense, a broader conversation that works two ways on some of those important issues. I wonder if, Mohammed, you want to come in on some of these important points about how to engage other audiences, in this case, the media, so that people can better, as Layla said, and others, the educated lay Muslim, the educated media can really use appropriately terms like fatwa, terms like fiqh, so that they don't fall back into some of those traps, some of those stereotypes, some of those misapprehensions concerning terms like Sharia or terms like fatwa that we mentioned earlier. Can you just comment on some of these issues?
Thank you, Layla. I think that's a very interesting observation. If you take this discourse, when this book was written, the Financial Times, a very leading British paper, gave a small op-ed review on its op-ed page. A chap called David Gardiner wrote the review. And if you read the review of the book in the Queen's Law Journal in Canada, the late Sonia Shakazmi, who did the review of the book, mentioned the fact that David Gardiner of the Financial Times received from readers of the Financial Times, who said that David Gardiner himself has now been co-opted by Sharia and by barbaric thinking. So the review on this book was like a book on itself. And a leading British Muslim barrister, Dr. Sonia Shakazmi, said that people didn't want to read the book. They wanted to castigate the person who reviewed it in the Financial Times, who said there's a lot to learn about it. So I think that gives you an indication of the type of Islamophobic trope in which this discourse fits today. And I think that it's a function of education. I think this type of a discourse we're having today with an outstanding Australian university, the University of Melbourne, and a standalone institute like the Institute of Ismaili Studies, gives us an opportunity for an educational discourse which is not based on mutual demonization or an apologetic discourse. Our discourse, hopefully today, is not to demonize as much as to use the principles of alternative dispute resolution, of recognition and enablement, a mutual respect to understand what are the issues that really go to the human condition. So I do agree with that point you say, Layla. There's a lot of work to be done, but this is where institutions like ours can contribute, but not only in the academic point. Matthew, I don't think this can be academics speaking to academics. I think we need to have it as a much more inclusive discourse. And I think Abdullah would also appreciate that point because he deals with communities. Abdullah not only is at the University of Melbourne, but Abdullah is situated in a living community that has to deal with daily issues of this nature. And I think it's an important thing for education for all of us, for Muslims and for non-Muslims.
Okay, great. That comment reminds me especially of the subtitle of your book, which of course is Islamic Law in a Globalizing World. And so we see, of course, Muslims referring to Sharia, referring to Islamic law in a way that, on the one hand, brings the community together, and yet at the same time draws them into a debate. But with reference to the Muslim community, we also see that this term, Sharia, has a particular significance. The community says we are bound together by Sharia. It's this word really identifies the community. And in fact, Muslims will turn to it as an identity marker. Who are we? We are a community that associates with the Sharia. And so this identity marker is something that we see happening within the Muslim community. We've spent most of our conversation talking about the ways others view the term Sharia. But I want to sort of finish with a final question about the way the Muslim community refers to the term Sharia, and ask about how you think they engage this term as an identity marker, really.
You know, Matt, identity, as you know, is a very complex concept. Now, I'm just looking at it from my own life and my own journey. And my co-author also was born like me, he was born in South Africa, brought up in Britain. And when we compared our own journeys in identity, they were so different. Rafiq was born in Natal, in Durban, in South Africa. I was born in Pretoria. And when we compared our own lives in South Africa, he was amazed. He said, "Is that what you went through under apartheid?" But I said, "Where the hell were you? You were also in the same country." He said, "We were in Natal, we were in Durban, we produced Gandhi. We fought the British colonial days 100 years before you guys." So identity is a very complex factor, number one. And each one of us, throughout our lives, we re-script our identity as we go through this journey. And I think I'm talking for all of us, Matt. I'm talking about you, I'm talking about Ziba, I'm talking about Lela, I'm talking about Abdullah, I'm talking about myself. I'm talking of all of us. But the issue is that we need to understand what is identity, what does it mean at any particular point in time for a person? And how is the Muslim identity shaped by Sharia? Is it a universal notion that every Muslim, wherever you see them in the world, will define themselves according to a Sharia identity? So both Rafiq and I did not veer towards what Joseph Schacht said. Joseph Schacht, in his book in 1949, 1950, says, the Sharia is the core and kernel of Islam in the face of a changing world. Our research has shown that's not true. I don't think it's true. Muslims don't use Sharia as the sole identity marker, though as time goes by, for different reasons. In Muslim majority countries or in diasporic contexts, Muslim may hearken to some parts of the Sharia as an identity marker, whether it will always be in the form of a hijab or always in the form of the type of beard you have or the type of dressing you have, or whether it will be a much more essential identity as they navigate through that route. But I would say that we need to understand the factors for identity politics playing itself out, either in a Muslim majority country, which is a clamor for greater social justice, or in a diasporic context, where it is a desperate attempt to say, we want to keep our identity in the face of a rampant globalization move. And I think that we would tend to say in this book that, yes, identity is to a large extent a factor, but it's not the factor. We are more towards what the late Harvard scholar Shahab Ahmed spoke when he said, what is Islam? That from the Bengal to the Balkans, Muslims drew on a wide panoply of influences, literary, music, artistic, a range of influences where a Muslim is able to draw from the multiplicity of voices that speaks to what it means to be a Muslim, rather than a very rigid juristic or jurisprudentially oriented approach. And I think that more and more as we come into the 21st century, that's what the discourse is going to be about. I mean, the very stark identity, ghettoized approach may not even work today. We have biracial marriages, a whole panoply of issues are taking place in the present global world, where we will have to think in a much broader context.
Terrific. This has been such a fascinating, multidimensional conversation, drawing on so many different layers of this topic, Understanding Sharia, from some of the things that Ziba was reminding us, that this conversation is a conversation of many voices, and we need to emphasize those many voices, to some of the things that Layla was pointing out about how important it is for our learning and our ongoing learning to be shared through the media, through other types of formats that will allow us to engage other people in an ongoing discussion about how these issues can be understood. I think that this discussion could go on and take many different directions, but I'm also conscious of time. And I just want to thank everybody so much for joining us, particularly our panel, Ziba Mir Husseini, Layla Arstal, and Abdullah Saeed, for joining us. But of course, particularly want to thank you, Mohammed, and your co-author for this incredibly helpful book. I think that people who are listening to this will hopefully be reminded that these sorts of collaborations between the Institute of Ismaili Studies, the National Center for Contemporary Islamic Studies in Melbourne, are really fruitful for bringing, as it were, the world together to talk about crucial issues. This is hopefully just one of several helpful discussions that we'll have. And I hope all of you and everyone who has joined us will come back again for another discussion, either in London or in Melbourne or wherever we may convene to discuss Islam and Muslims across the Muslim world and try to understand a little bit better. So thank you very much for joining us, everyone.
Thank you, Matt. Thank you, the panel. Wonderful, wonderful day. Thank you so much.